afternoon. Thank you all for being here. I'd like to introduce a few of our participants for today, starting from my far left, the District Attorney of Nassau County, Kathleen Rice. Thank you very much for being with us.
Thank you,
Kathleen, the District Attorney from the County of the Bronx, Robert Johnson. Pleasure to be with you. The District Attorney from New York County, otherwise known as Manhattan, Cy Vance. To my right is Counsel to the Governor, Mylan Dennerstein, the Staten Island District Attorney, Dan Donovan, and the Rockland County Attorney, Tom Zugaby. We want to thank you all very much for being here. I'd also like to thank all the other district attorneys who have cooperated with us over the past few days in coming up with today's announcement. I'll have an opening statement, then I'll turn it over to Counsel Mylan Dennerstein to go through a law that we're proposing today, and then District Attorney Vance will have a comment, and then the floor will be open. Over the past few days, there have been several charges brought against public officials. They span city and state government. They span Democrats and Republicans. And they paint a truly ugly picture of our political landscape. I'd like to say that this is an unprecedented situation, that public corruption is a new problem, but it isn't. And in many ways, that's what makes it worse. There have been too many incidents for too many years. Perhaps most disturbing is that these particular complaints show especially brazen and arrogant behavior. That is why this is the moment to redouble our reform efforts. The old law enforcement adage is follow the money. Well, that's true in political cases also. And let's begin at the beginning. How does one's name get on the ballot? One of the recent charges raises serious questions on the New York City mayoral process. The question of cross-endorsements by political parties of one candidate. The application of what's called the Wilson-Pakula law, which was passed in 1947. Which governs this area. Follow the money leads to our campaign finance system and to questions of public finance. Politicians need extraordinary amounts of money to run for office. It's a very expensive endeavor. That leads to the need for high campaign contributions, and that leads to what we call the pay-to-play culture. There are also larger issues to be addressed at the same time. Why can't we get better people to run? How do we open up the process and get more competition? These are all big and important issues, and we must and we will address them. But today we start at the beginning, and we start with stricter and more effective criminal deterrence. Let us affirm and expand a simple fact. If you are a public official, and if you break the law, you will get caught, you will be prosecuted, and you will go to jail. As Attorney General, I made that abundantly clear when I prosecuted elected officials and sent them to prison. The United States Attorney for the Southern District, Preet Bharara, has shown his commitment to and capacity in bringing public integrity cases. We applaud him and we thank him for his outstanding public service. And today we propose measures to ensure that all of our 62 district attorneys have the proper laws to expeditiously investigate and prosecute public integrity violations. Today we are proposing new criminal laws dealing exclusively with public corruption. Our proposal includes 3 new laws: bribing a public official, scheming to corrupt the government, and failure to report public corruption, which for the first time will place an affirmative duty on public servants to report attempts of bribery and corruption. It also increases criminal penalties on existing laws in terms of public officials and public acts. My counsel, Mylan Dennerstein, will give you more details on that in a moment. On these proposals, I will seek legislative approval this session because we need progress, and we need progress now. That is not to say that we can legislate away this problem. Power will corrupt. There will always be greed and arrogance. There will be criminality in every field and every sector. But this is a journey and it is not a destination. And we can and we must do better. We won't rest until the system ensures government integrity by doing our best to prevent violations in the first place and to ensure punishment if there are offenses. New York State has a zero tolerance for public trust violations. The people demand nothing less. That is the way it must be, and that is the way it will be. With that, I turn it over to Mylan Dennerstein.
Thank you, Governor. Governor Cuomo will be proposing the Public Trust Act, which will change New York state law so our prosecutors can effectively root out and punish public corruption across our state. The Public Trust Act includes new and expanded crimes for public corruption, tough new penalties for those that defraud our state's taxpayers, and long-term protections so those convicted of public corruption felonies never have the opportunity to defraud New Yorkers again. To provide you with a little bit of more detail, the first new and expanded crime is bribery of a public servant. Under current state law, a prosecutor must prove that there was a corrupt agreement or understanding between the person paying the bribe and the person receiving the bribe. This is not required under federal law and places an unduly heavy burden on prosecutors. The Public Trust Act will close this loophole. So even in cases where there is not a corrupt understanding between two parties, the person offering the bribe or accepting the bribe can be held accountable. And it will also increase the penalty so that the perpetrator is properly punished. There also are a new class of crimes corrupting the government. The Public Trust Act, for the first time, holds accountable and increased penalties on anyone, whether or not they are a public official, who is found to have defrauded the government, whether or not they are acting in concert with a public official. And as the governor mentioned, reporting of public corruption. The proposed legislation would for the first time make it a misdemeanor for a public servant to fail to report bribery. Tough new penalties are needed and necessary. The Public Trust Act recognizes that the crimes of public corruption should be treated more seriously than other crimes because they do particular harm by breaking all of our trust in our system of government. It is all about our taxpayer dollars. The Public Trust Act would create new penalties for offenses such as fraud, theft, or money laundering when it's involved in stealing from the government, which is essentially what this is all about, stealing from the government. The sentence would be one level higher than it would be if it was just grand larceny. For example, if under the underlying offense you would have received a Class D felony, then that would it'd be increased to a Class C felony. Also, under current law, official misconduct is simply a misdemeanor. The proposed legislation makes official misconduct 3 different felonies based on the severity of the conduct. And as for long-term protections, we need to make sure New Yorkers continue to be protected from those found guilty of crimes of public corruption. The Public Trust Act would include additional criminal fines, also permanent bars on all those convicted of public corruption felonies from holding any elected or civil office, doing business with the state, including through any organization in which they're a fiduciary or a principal, to prevent the repeat companies coming back and back before the state. Also, we're proposing other tools for district attorneys, including changing the statute of limitations for public officials, which is in effect now for 5 years after they have left office, but does not apply to non-public officials who act in concert with them. The legislation closes this loophole, applying the same statute of limitations of 5 years to both public servants and other individuals who collaborate to defraud the government, enhancing prosecutors' ability to bring strong cases. And in addition, a witness who testifies before a grand jury investigating public corruption or official misconduct will receive only use immunity under this proposal, not transactional immunity, for statements the witness may give under oath. This means that the witness, who may or may not have also been part of the crime or criminal transaction under investigation, may still be prosecuted for his or her role if the prosecutor develops evidence other than and independent of the statements given by the witness. This is a seriously important tool in fighting crime and will help to conform New York's practice with federal practice in this area. With that, I'd like to turn it over to the DA's Association's President and the Manhattan District Attorney, Cy Vance.
Thank you, Mylan, and Governor Cuomo, thank you very much. Thank you so much for moving on this important legislation. Since taking his office, us in the District Attorneys Association have truly believed the governor has been a strong ally of law enforcement, passing critical legislation like expanded DNA collection, stronger domestic violence laws, and more effective firearms controls. Those laws have all helped to protect New Yorkers in the streets and in our homes, and will do so in the future. Today's legislation is another important step on behalf of the governor toward protecting New Yorkers from corrupt public officials and those who would line their pockets with public dollars. Just like the public needs confidence in the fairness of our criminal justice system, so too does the public need to have faith that the men and women entrusted to do the public work are doing so, and are doing so honestly. The public expects elected officials to conduct their dealings ethically and honestly, and it's time that our laws caught up with reality. Since I took office in 2010, I've advocated strongly for laws that give state prosecutors more tools to investigate and prosecute corruption at all levels of government. Under the new class of crimes proposed by the governor, prosecutors will be able to pursue defrauding the government and bribery more aggressively, criminalizing activities that have been wrong but legal for far too long. It also gives us, as Mylan indicated, a bump up or enhanced penalties when thefts are committed against public entities, like someone stealing from Medicaid, regardless of whether or not they're a public official. In our opinion, as prosecutors, these are very sound proposals, and they have the support from district attorneys across our state. Each of us, as DAs, know that no corner of our state is immune to corruption, and we have to protect our taxpayers from Brooklyn to Buffalo. The public deserves nothing less. Governor Cuomo, thank you so much.
Thank you. Let me thank the district attorney again in both capacities, both as the district attorney of Manhattan, New York County, and as the head of the District Attorneys Association. And I want to thank the District Attorneys Association for really tremendous cooperation, not just on this effort, but over the past 2 years. I want to thank them very much. And also welcome representatives from the Queens District Attorney and the Brooklyn District Attorney's Office. Floor is now open. Sorry?
I see here that this is giving local district attorneys more resources to go after their public corruption. Why not give the state attorney general more?
Well, this is step one for us, Zach. We are looking at criminal laws, and the district attorneys, as you know, are primarily the people charged with criminal enforcement. We're going to be looking at other areas going forward: campaign finance laws, public finance laws, the electoral process, Board of Elections enforcement. And that's one of the areas we're going to be looking at is additional enforcement responsibilities in those areas, including possibly using the Attorney General in some of them.
Where do you stand on that idea of the Attorney General having broader jurisdiction? This was raised in 2010, so it's been out there.
I think the Attorney General can be helpful in campaign finance enforcement, Board of Elections related enforcement. For sure, I think the Attorney General can be especially helpful in Charities Bureau enforcement. So those are areas that we want to explore. The district attorneys are the primary, I was a former Attorney General, and I worked in that capacity with the District Attorneys Association. The district attorneys are the primary criminal law enforcement agents in this state. That is primarily their jurisdiction, and that's why we're speaking with them today. The Attorney General obviously has an important role, and it's an important office, and our quest is to maximize the capacity of all offices.
Will this be pushed over as part of a package of reforms? For example, will it be grouped in with campaign finance? Is something I know you expressed interest in.
We're looking, Zach, to do an overall reform package. We had previously talked about doing campaign finance reform and public finance issues, some ethics reforms. I think given the recent events, I think we can put together a more robust reform package. And I think the legislature will be receptive. As I said, we were chatting inside before we came out. I think the legislative bodies in general tend to respond to current events, and they respond to the people of this state. I think the people of this state have a high level of concern given these revelations over the past week or so. And I think the legislature understands that, and I think they're going to have a willingness for a broader reform package. And I want to strike while the iron is hot. A crisis is a terrible thing to waste, and we're going to have a very robust package of reforms and work very hard to get them passed.
Looking at a project.
You mentioned the quote is saying that part of the problem of corruption is entrenchment of leadership in Albany. Would you support term limits for members of the Assembly and State Senate?
I don't, it's a valid question, it's a valid issue to be discussed, and I think I would welcome a dialogue and discussion. I don't personally support term limits. I believe we have term limits. It's when people vote you out of office. My father was term limited out of office. Democracy ultimately works. So it's not my position, but I understand there's a difference of opinion, and I think it's something that should be looked at.
Governor, last week when Assemblyman Stevenson was charged by the U.S. Attorney, there was a witness that was developed by Bob Johnson in the Bronx, and he had to turn that witness, also an Assemblyman, over to the federal government. Will these laws make a difference in those kind of prosecutions where local DAs will prosecute as opposed to federal prosecutors? And do you think that that's the right place for local corruption to be prosecuted?
Well, Marcia, it's a good question. I can tell you this, and I'll ask the district attorneys for their opinion. When I was Attorney General, I turned some cases over to the U.S. attorneys because the federal laws are actually easier on public corruption, public integrity cases. And the state laws don't afford a prosecutor as much ability as the federal laws. This will go a long way towards giving in my opinion, the district attorneys the kinds of tools they need and the kinds of laws they need to actually bring these cases. And when you've talked to the DAs historically about getting involved in public integrity, public corruption cases, many of them will say the state law doesn't make it easy. As a matter of fact, the state law makes it very hard. And the federal law was different. And that's why you tend to see historically the U.S. attorneys more aggressive in this area. So I think for sure these laws will empower now the DAs to bring these kinds of cases all across the state, right? Because you have a state government, we've been talking about New York City government and the state government. You have county governments, town governments, village governments, right, all across the state. And our desire for zero tolerance of any public integrity violations is in every government all across the state. But maybe one of the district attorneys would like to comment. With these law changes, are you in a better position to bring these types of cases?
Well, Governor, I'd jump in and say yes. Number one, the substantive law changes, as in changing the law of bribery, is an example of how we are really lining up under the governor's proposal state law to federal law, enabling us to investigate criminal conduct, which is bribery, in ways that we could not in the past. But Ms. Dannerstein also focused on a very important procedural change proposed in this law, and that's the difference between use immunity and transactional immunity. And that is really one of the strongest impediments in our state grand jury system from being able to conduct investigations as the federal government is able to conduct them. Because when you put a witness in the grand jury in the state system, unless they waive immunity, they get absolute immunity for anything that they talk about. And it's absolute. And when you put a witness in the grand jury, state prosecutors should not be shooting in the dark. And if someone is in the grand jury and later turns out to be culpable for criminal misconduct, for us not being able to pursue those kinds of cases. So this procedural change of use immunity is huge. I think it shows, in my personal opinion, courage on the part of the governor to propose this change, and I hope the legislature will adopt it and give the state prosecutors the tools to conduct these investigations that have been used so successfully and I think appropriately by our federal brethren.
Governor, the second part of the question was, do you think that these cases should rather be prosecuted on the local level as opposed to giving it to the federal government?
I think, Marcia, the more Well, look, under the, as I said before, as Attorney General, I turned over some cases to the federal officials just because from an investigative point of view, we had the assets and the resources, but the federal law was actually better. I think this is going to go a long way to give the district attorneys, empower the district attorneys. But look, the U.S. attorneys have been doing great work here. The U.S. Attorney for the Southern District, Preet Bharara, has been doing great work. So I would encourage them to continue. They're doing great. But now that the DAs also are empowered, and my position is this, you can't have, when it comes to public integrity, you can't have enough police officers on the beat, right? You can't have enough sets of eyes. And again, we're not just talking about the city government, you're not just talking about the state government, you have local governments all across the state. And we want the district attorneys as helping ensure public integrity all across the state.
I think what the governor's proposed evens the playing field. There's a lot of times when we decide whether to prosecute a case state or federally, part of that is the penalties that would be incurred upon a conviction. A lot of it's the rules of evidence, the rules of procedure. The governor's proposal kind of evens the playing field out for us. Now we could decide, we could prosecute cases that in the past would have been better prosecuted federally, now might be better prosecuted statewide because of the new proposal.
Do you have the resources to do that presently in your office?
I could always use more resources. I don't
He
think
has
that-
the resources. No, he doesn't.
Governor, do you agree with Ms. Bharara that there's pervasive corruption at every level of government in New York State?
I think there is, I think there is corruption to some extent, in almost every government, to the extent you have some level of fraud in almost every corporation, criminality is widespread. The old adage that power corrupts, government is a place of power. It is a place with access to funds. So, and it's human behavior. We were chatting earlier. I think these laws are going to make a big difference. I think the prosecution will make a big difference. You're not going to legislate away criminality and greed and venality and abuse and arrogance. I mean, in the charges brought last week, you had people openly saying, we know this is illegal, we know that people have done this in the past, we know people have gone to jail, and they're still doing it, There's also an ignorance factor that is at work, and arrogance and ignorance, it doesn't matter what the law says, it's human behavior. So what we can do and what we must do is everything you can do to make sure the system prevents abuses, and if there is an abuse, if there is a violation, you find out about it and you punish it. And that's the system that we're putting together.
Looking at a project the size of the Tappan Zee Bridge, several $1 billion impacts Rockland, Westchester, the entire Hudson Valley. How would this specific legislation ensure that corruption doesn't touch a project of that size?
Well, for example, you have two great district attorneys on both ends of the bridge, Westchester and Rockland. This will give them more tools, more ability to investigate and prosecute these kinds of cases. We don't anticipate any problems with the Tappan Zee Bridge whatsoever, and we're scrupulous, but they will have more tools to do exactly what we're talking about today in terms of public integrity.
Governor, when did your staff begin working on these proposals, and why didn't you pursue this as part of the ethics law in 2011?
These proposals have been discussed for some period of time, and the district attorney's office just completed a task force, I believe relatively recently, and came up with many of these proposals which we had been reviewing.
Governor, do you see a problem in that these district attorneys are elected and they raise money from some of the same sources in the same system that has seen so many problems? I mean, is there a problem with that in terms of their credibility? Would it be appropriate for something in this law to hold them responsible if they don't bring a prosecution when there's evidence of corruption?
In this state, at one point you have to charge someone with the responsibility, right? And there are two basic ways that you can select a person. A person can be elected by the people, or a person can be appointed. Some prosecutors are appointed. Some attorney generals, by the way, are elected. Some attorney generals are appointed. Both systems of selecting attorney generals are criticized. Some say you shouldn't appoint an attorney general. You shouldn't appoint a law enforcement officer because there's no accountability. And the president picks a U.S. attorney. In some states, a governor picks an attorney general. And some people criticize the appointed process. Some people criticize the elected process, right? Elected process, you are accountable to the people. And if we have to default to a system, I think the elected system is the best we have. But you can critique either appointed or elected, and people do.
Governor, I thought it was interesting, the proposal, only because I guess U.S. Attorney Barrar said basically claimed that the culture, the political culture has turned a blind eye to corruption, and you have a proposal here, failure to report public corruption that would include make it a misdemeanor for any public official or employee who fails to report bribery. Has that been enacted in other states? And would this cover any and all government employees, or how far would this go? And do you believe this is something that can be effectively prosecuted?
It is a very aggressive proposal. It has been done in a couple of other states. It's a very aggressive proposal, and basically what it says is a public official has a duty to report attempted corruption or corruption that's actually being committed. And it gets just to that point, Carl, which is if you're a public official, you do have a duty, and we do hold you to a higher standard as a public official. And the statute, the law that goes along with that higher standard is if you believe, to the best of your information, that there is a corrupt incident going on or an attempt at corrupting a public official, you have a duty to come forward and report it.
How far would it go? Like it says employees, would it cover all government, municipal employees, county employees, state government employees? Can you specify on that?
I would have to find out for you. Public officials is the definition. I don't know how far down public officials goes.
Governor, you said yesterday that you wouldn't presume to tell the assembly who their leadership would be, but do you feel as though in both houses that there has been kind of a blind eye turned to this? Has enough been done to root out corruption in the respective houses?
You know, as I said, this has gone on, in some ways this is nothing new, and that's what makes it worse. There has been a long list of public officials who get into trouble. By the way, not just in this state, you know, in every state across the country. You have a bad combination of chemicals. You have power, you have money, you have ambition, you have greed. You put all those chemicals in one test tube and you shake it up, and bad things happen. So there has been a continuing and repeated string of these violations. Now, we passed an ethics bill last year. We came up with JCOPE last year. 4 years as Attorney General, I did some of the most high-profile public corruption cases. Former sitting controller of the state of New York literally went to prison. So there are some people who still don't get it, and obviously there are some vulnerabilities in the system. And I use the expression, in some ways it's a journey more than a goal. Will you ever stop all public integrity abuses? No. No, not unless we change the human behavior patterns and human nature. You know, you will have abuses. But our obligation is put together the best system you can to stop them, prevent them, catch them, and punish them when you do.
Governor, two questions, if I could. First of all, do you think these officials go to Albany corrupt? Your opinion, or do they get corrupt when they go there, number one? And number two, you mentioned that there are laws in place. They know there are laws in place. Why is this to make a difference? Why is this that bill to make a difference?
Well, in the cases that were brought last week, two of them were relative newcomers. So on your question, which is an interesting one, my guess is, you know, it was at the very beginning of their tenure. So I don't think you could say it was a result of their service. It was at the very beginning of the service. I guess it depends on individuals. Some people may find the temptation earlier. Some people may be tempted later. I don't know. I think it depends on the individual.
Last one, Anna. And why is this set of bills to make a difference? They already know it's against the law.
Well, they know it's against the law, but we believe that deterrence, surety of being caught and being punished, is one of the best ways to have a deterrent to the system. And what this will do is empower the 62 district attorneys all over the state. We're going to have many more eyes on the process, many more prosecutors involved, many more investigators involved. If someone is acting at all reasonably or out of self-preservation, the likelihood that any violation will be found out, investigated, convicted, just went up exponentially, right? Because you're going to have many, many more people involved.
Governor, you mentioned there's an appetite among legislators for more robust reform. What specifically can you tell us about the reception to the idea that cross-party endorsement sitting with them changing the threshold for ballot access? What kind of conversations do you have on this about?
You know, we haven't gone through individual items yet, but it's fair to say that the legislature responds to the people of the state. You know, they teach us in high school civics, we are taught that the elected officials lead and the people follow. Sometimes it happens the other way around. Sometimes the people lead and the politicians follow. Legislatures often respond to what the people want. And I think over the past few weeks, they've gotten a lot of information about corrupt acts, and the people want something done about it. I frankly hope that the people's appetite remains high, because sometimes people move on, but I think this legislature is going to come back into session. They know that we have to do something about this. People want something done, and I think that's a good thing. I think it's an opportunity for us. But I haven't gone through specific items of a reform agenda with them. We had been talking about campaign finance. We had been talking about public finance. We had been talking about some electoral reform issues, but I haven't had in-depth conversations to go point by point.
Think there have been conversations about this particular proposal with the Speaker Silver?
Only generically.
Governor, do you think if you paid lawmakers more money, they'd be less inclined?
You know, Marcia, one of the questions that, on the big questions, how do we get better people to run, term limits we talked about, I think one of the big questions is, should we have a full-time legislature? You know, when you have a part-time legislature, you pose many more potential conflicts. People are practicing law, they have clients have an interest before government, they're also a legislator, people are in business, just the number of potential conflicts goes way up. Now, full-time legislature is also problematic. It was supposed to be a citizen legislature, you'd have to pay people more. Some people think if they are actually in Albany more, they'll do more harm. But I think it's one of the questions that should be looked at. Any of my colleagues have any other comments?
That's good, Governor.
Johnson comment about the fact that he had to turn over Nelson Castro to the bench?
Well, I would never say it's not always a had to. There's a whole equation, as the governor and District Attorney Donovan spoke about. That there are decisions we have to make in every case. This particular case, in addition to that equation that always exists about better laws of evidence, better punishment, was also the fact, the awareness that the U.S. Attorney was doing these kind of cases, and the uniqueness of having an assemblyman in place who could get information. So that's something on my part that I wanted to share with the U.S. Attorney. I think that's a factor also. It was a rare opportunity, and assessing it all, that's the side we came down on, working together. I think what the bottom line is in every single case is what's going to provide the best result to bring about all the wrongdoers before the bar of justice and actually have them convicted and sentenced.
I guess my question is this: if these new laws that the governor is proposing had been in place, would that have affected your decision
In similar cases, yes. In this particular case, I still wanted the U.S. Attorney to have the opportunity to avail himself of this particular cooperator.
Okay, thank you all very much. Thank you. I'd like to thank my colleagues once again.